A Supreme Court ruling from over a year ago is still making headlines right now, and most people have no idea the fight never actually ended. On April 7th, 2025, the Supreme Court split 5-4 in a case called Trump versus J.G.G., vacating a federal judge's order that had blocked deportation flights under an 18th century wartime law. Most coverage treated that as the end of the story. It wasn't. In the 16 months since that ruling, the underlying case has bounced between a federal judge in Washington and a federal appeals court, produced a criminal contempt finding against administration officials, triggered a fight over whether that contempt inquiry could even continue, and as recently as this past spring, resulted in an appeals court shutting the entire contempt investigation down. If you thought this story was resolved on April 7th, 2025, you're missing most of what actually happened. And you're not alone, because the news cycle moved on almost immediately. While the actual legal fight kept grinding forward in courtrooms, most people stopped watching. I'm going to walk you through the full timeline, from the original deportation flights through exactly where things stand right now, so you understand not just what the Supreme Court decided, but what happened after, because after is where this story has actually lived for the past year and a half. Before we get into the timeline, if you want to follow stories like this all the way through instead of just catching the first headline and assuming it's over, subscribe and turn on notifications right now. Most channels move on the moment a big ruling drops, chasing whatever the next headline is instead of following through on the story they already started. I keep tracking cases like this one until they're actually finished, checking back in every time something new happens in the lower courts, and this one still isn't finished. Let's get into exactly what happened and what's happening right now. Here is where this all started. On March 15th, 2025, the Trump administration invoked the Alien Enemies Act, a 1798 law that allows the president to detain and remove citizens of a hostile nation during a declared war or invasion, and used it to begin deporting men the government identified as members of the Venezuelan gang Tren de Aragua directly to a maximum security prison in El Salvador called CECOT, without the individualized removal hearings normally required under immigration law. A group of the men facing removal sued, and U.S. District Judge James Boasberg in Washington, D.C. issued a temporary restraining order that same day, blocking further removals. According to Boasberg's own later account, he specifically ordered that any deportation flights already in the air be turned around and brought back. That order was not followed. The flights landed in El Salvador, and roughly 137 men were transferred into CECOT custody. That single decision, not turning the planes around after a judge's order, is the seed that grew into everything that followed for the next year and a half. The first segment of the timeline is the sprint to the Supreme Court, which happened remarkably fast by the normal standards of federal litigation. Boasberg's order got expanded into a nationwide class action covering everyone facing removal under the same proclamation. A divided federal appeals court in Washington declined to lift his order. The administration went straight to the Supreme Court on an emergency basis, and on April 7, 2025, just over 3 weeks after the original deportation flights, the court ruled 5-4 to vacate Boasberg's order, holding that challenges to removal under the act had to proceed through individual habeas corpus petitions filed in the district where each person was actually confined, in this case Texas, not through a nationwide class action in Washington. Justice Sonia Sotomayor's dissent, joined by Justices Kagan and Jackson, and joined in significant part by Justice Amy Coney Barrett, a Trump appointee, argued the ruling effectively rewarded the administration's decision not to comply with Boasberg's original order, and warned of what she called life-or-death consequences for the men already sitting in a foreign prison. That ruling closed one chapter. It did not close the case. The second segment is what Judge Boasberg did next, because his role in this story was far from finished once the Supreme Court's procedural ruling came down. Even with his original class-wide order vacated, Boasberg still had authority over the specific question of whether administration officials had violated his original order by not turning the planes around while it was still in effect, since the Supreme Court's ruling addressed only where future challenges to removal had to be filed going forward. not whether officials could be held accountable for what had already happened under an order that was still legally binding at the time the flights landed. He opened an inquiry into that question, and by the following month, found probable cause to hold administration officials in criminal contempt, writing that the government's refusal to turn around the deportation flights amounted to a willful disregard of a standing court order, language he chose deliberately because it goes to the heart of whether a federal court's orders can simply be ignored by the executive branch while an appeal is pending. Boasberg's ruling specifically noted that his original order had been issued and communicated to government lawyers before the flights landed, meaning the administration had a genuine opportunity to comply and chose not to. A factual finding that became the central, disputed premise underlying everything that followed in the contempt fight. This contempt inquiry became its own separate, extended legal battle running almost entirely independent of the underlying dispute over the lawfulness of the deportations themselves. The third segment is the year-long fight over whether that contempt inquiry could even proceed, and this is the part of the story most people watching only the original ruling never saw unfold. The Trump administration immediately appealed Boasberg's contempt finding to the D.C. Circuit Court of Appeals, and in April of 2025, a divided three-judge panel, split 2-1 along the lines of which President appointed each judge, temporarily halted the contempt proceedings while the appeal was considered. The two judges in the majority, both appointed during Trump's first term, sided with the administration, while the dissenting judge, an Obama appointee, wrote that there was no appealable order and no clear right to relief that would justify pausing the case at that stage. The underlying merits case, meaning the actual question of whether the Alien Enemies Act was being lawfully applied to these specific men, kept moving forward in Boasberg's court on its own separate track during this entire period. Now proceeding through the individual habeas framework the Supreme Court had specified, rather than through the original class action. By November of 2025, 7 months after the contempt inquiry had first been paused, Boasberg announced he intended to move forward with it, telling the parties in court that the matter had been sitting for a long time and that he believed justice required him to proceed promptly, a comment that made clear the delay had not softened his view of what had happened back in March. That announcement triggered an immediate new round of emergency appeals from the administration, and in December of 2025, the D.C. Circuit again intervened, this time granting an administrative stay just before two Justice Department officials were scheduled to testify, explicitly noting the stay should not be read as a ruling on the actual merits of whether the contempt inquiry itself was proper, only as a pause while the court considered the question more fully. That December stay drew its own controversy, because one of the officials whose testimony was blocked, a Justice Department lawyer named Emil Bove, was at that exact moment going through his own separate Senate confirmation process for a federal judgeship, and critics argued the extraordinary length of the administrative stay raised real questions about whether it was being used to shield him from testimony that could complicate that confirmation, an accusation the courts involved never formally addressed one way or the other. The fourth segment is how this entire contempt fight finally resolved, at least for now, because it did reach a real conclusion, just not the one either side necessarily expected this early. In April of 2026, a full year after the Supreme Court's original ruling, and roughly a year after the contempt inquiry had first begun, the D.C. Circuit Court of Appeals shut the contempt investigation down entirely. The majority on the appeals panel described Boasberg's continued pursuit of the contempt inquiry as an improper judicial intrusion into the autonomy of a co-equal branch of government, effectively ending, at least at this stage of the litigation, the year-long effort to hold specific administration officials personally accountable for not complying with the original March 2025 order. This ruling did not touch the separate, ongoing merits litigation over whether the underlying use of the Alien Enemies Act against these specific men was lawful in the first place. That fight continues on its own track, but it did close out, at least for now, the specific question of whether officials could face contempt sanctions for the decision not to turn the planes around back in March of 2025. The fifth segment is what happened to the actual men at the center of this entire story, because it's easy to lose track of the human reality underneath more than a year of procedural fighting between courts. The roughly 137 men transferred to CECOT in March of 2025 remained in that facility for an extended period, while the underlying legal fight over their status played out far above their heads in courtrooms in Washington and Texas. Their individual cases proceeded through the habeas framework the Supreme Court had mandated, meaning each man's specific situation had to be evaluated separately in the specific court with jurisdiction over wherever he was being held, rather than resolved all at once through a single nationwide ruling. That individualized process, exactly the kind of process the Supreme Court's majority said the law required, moved considerably slower than a single nationwide injunction would have, which is precisely the practical consequence Justice Sotomayor's dissent warned about when she wrote of the compressed and difficult path facing each individual detainee under this framework. Separate litigation involving at least one of these men drew particular national attention when a federal judge in a different case ordered the administration to facilitate the return of a man who had been deported despite an earlier judicial protection against his removal to that specific country. A case that proceeded on its own track through a different federal circuit entirely and became its own flashpoint in the broader debate over whether the administration was complying with court orders governing this set of deportations. Family members, immigration attorneys, and human rights organizations tracking conditions inside CECOT raised ongoing concerns throughout this period about the men's treatment and access to legal counsel, concerns that became harder to independently verify given the facility's location outside U.S. jurisdiction and the limited access afforded to outside monitors. A dynamic that added real urgency to the underlying legal debate over how much process was actually owed before removals like these took place. The sixth segment is the bigger picture this case fits into, because Trump versus J.G.G. did not happen in isolation. Legal analysts tracking the Supreme Court's emergency docket have documented a broader pattern since this ruling, of the administration bringing an unusually high volume of emergency applications to the court, and the court granting relief to the executive branch through unsigned, expedited orders at a rate significantly higher than in previous years, across a wide range of policy areas well beyond immigration, from federal agency removals to funding disputes to other executive actions facing nationwide injunctions in lower courts. Researchers tracking these numbers found that where the Obama and George W. Bush administrations combined filed only a handful of emergency applications with the Supreme Court over 16 years, the current administration filed dozens in its first year alone. A dramatic shift in how frequently the executive branch is turning to the court's fastest, least explained process to resolve disputes with lower courts. Legal scholars and even some of the justices themselves have written publicly in the time since about growing unease with how much of the country's most consequential legal questions are now being resolved through this fast, minimally explained emergency process, rather than through the court's normal, fully briefed and argued procedure. Trump versus J.G.G. is frequently cited as one of the clearest early examples of this shift, precisely because the underlying dispute, a wartime deportation law being applied to gang members without individual hearings, was serious enough that the compressed 3-week sprint from the original court order to a final 5-4 Supreme Court ruling left very little time for the kind of careful, deliberate consideration that questions of this magnitude have traditionally received. Other cases decided on the same emergency docket in the months since have touched on immigration enforcement tactics, the removal of officials from independent federal agencies, and a range of other disputes where lower courts had issued nationwide injunctions against executive action. And legal observers increasingly point back to the reasoning first laid out in the J.G.G. order as a template the court has leaned on repeatedly since. Before we get to what comes next, it's worth pausing on how differently the two sides of this dispute read that April 2026 shutdown of the contempt inquiry, because it captures the same underlying disagreement that's run through this entire case from the beginning. Supporters of the administration's position argued the D.C. Circuit's decision to end the contempt investigation was a necessary and overdue correction, framing Boasberg's year-long pursuit of individual officials as exactly the kind of judicial overreach into executive branch functioning that the original Supreme Court ruling had already tried to rein in, and pointing to the panel's own language about improper intrusion into a co-equal branch as vindication of that broader argument. Critics of the administration's position argued the opposite. that shutting down a criminal contempt inquiry into officials who, by Boasberg's own factual finding, willfully disregarded a standing federal court order sends a troubling signal about whether court orders can simply be ignored by the executive branch without meaningful consequence, while an appeal works its way through the system regardless of how that appeal eventually resolves. Both readings are grounded in real, coherent principles about how the separation of powers is supposed to function, one protecting the executive branch from what it sees as judicial micromanagement of its internal decision-making, the other protecting the judiciary's basic ability to enforce its own orders while a case is still pending. Neither side has fully won this argument, because the underlying tension between those two principles is exactly what makes cases like this one so difficult to resolve cleanly, and exactly why it took a full year of appeals just to settle the narrower question of whether the contempt inquiry could proceed at all before ever touching the actual merits of the deportations themselves. The seventh segment is what to actually watch for if you want to follow where this specific case goes from here, because despite everything that's happened, it still isn't finished. The underlying merits litigation, the actual question of whether Tren de Aragua's activity in the United States constitutes an invasion sufficient to trigger the Alien Enemies Act in the first place, continues moving through the individual habeas cases in the courts with jurisdiction over each detainee. Any ruling on that underlying merits question, as opposed to the procedural rulings we've covered so far, would represent the first time a court actually decides whether this specific use of an 18th century wartime statute against gang activity, rather than a formally declared war, is lawful at all. If you want to track this yourself, the concrete step is to follow filings in the individual habeas cases proceeding in the relevant federal districts, distinct from the now closed contempt proceeding in Boasberg's court, because that merits question, not the contempt fight that just ended, is where the actual legal precedent about this specific use of the Alien Enemies Act will eventually get set. Let's step back and name what this year and a half actually shows about how major legal disputes involving the executive branch really unfold in real time. A single Supreme Court ruling, even a consequential 5-4 decision covered extensively in the news the day it happened, is very often just one chapter in a much longer story, one that continues through separate contempt proceedings, competing appeals, shifting procedural postures, and years of individual litigation that rarely gets the same attention as the original headline-grabbing ruling. The gap between what most people remember about April 7, 2025, a Supreme Court win for the administration on emergency relief, and what actually happened over the following 16 months, an extended contempt fight, a year-long battle over judicial authority itself, and merits litigation that is still ongoing, is exactly the kind of gap that leaves people confidently repeating an outdated version of a story that has actually kept moving without them. It's worth being honest about why stories like this one lose their audience partway through, because it isn't really anyone's fault in particular. A 5-4 Supreme Court ruling makes for a clean, dramatic headline. A year-long appellate fight over whether a contempt inquiry can even proceed, decided 2-1 by a panel most people have never heard of, does not generate anywhere near the same attention, even though it's arguably just as consequential for understanding how accountable the executive branch actually is when it disregards a standing court order. That mismatch between what's dramatic enough to trend and what actually determines how the law functions in practice is a big part of why so many major legal stories end up frozen in the public's memory at whatever moment generated the biggest initial headline, while the parts of the story that unfold slowly in appellate filings and scheduling orders and quiet procedural rulings simply never reach the same audience. If you take one thing away from this breakdown, let it be this. When a major Supreme Court ruling drops, especially one decided on the emergency docket with a short, unsigned order rather than a full opinion, that is very often the beginning of the next phase of the fight, not the end of it. The version of this story that stopped paying attention after April 7, 2025, missed a criminal contempt finding, a year-long appellate battle over whether that contempt inquiry could even proceed, and an appeals court finally shutting it down just months ago, all while the actual underlying legal question about this use of the Alien Enemies Act remains unresolved to this day. Whatever you believe about how this case should ultimately be resolved, on the merits or on the contempt question, understanding the full 16 months rather than just the opening headline is what separates an actually informed opinion from one built on a story that stopped updating over a year ago. If this helped you catch up on everything that happened after the headline you remember, share it with someone who thought this story ended over a year ago. Subscribe so you catch the next development in this case the moment it happens, and I will see you in the next one.